that. But we also know at this particular stage, and the people of Kenya know, and that is why this is an open court proceedings, that when the courts in Kikuyus were being banned, when in Nyahururu courts and other administrative sessions were being banned, in Dagoretti, and even this hospital, somewhere in Kiserian, and even Homa Bay, which is, of course, that one is an exempted case, that were, when they were being banned, we saw young men on video. These young men, as we speak here today, they have not been arraigned in any court, before any court. So that, Your Honor, because again, it is the kind of thing that was also addressed in the famous court of Githunguri, the question becomes, how, under what circumstances are we having people against whom there is no video evidence are being dragged into courts and being called criminals? But people who have been caught on video evidence, some of them like in Kiserian, when they attacked the hospital, they didn't even bother to mask themselves. But they are not before any court. In case they said, you are going to disgrace the judicial system. You are going, this is going to be an abuse of the administration of justice. Because, Your Honor, if we say, who banned Kikuyu police station, we can only say we must start with those that we saw on the video doing it. But when a man who was not in that video is presented before you, there must be something wrong about it. And the courts must do something about it. Such a person cannot just be processed as a criminal for purposes of making a political statement. Your Honor, the issue of terrorism as a general issue is one that I believe it was Mr. Ondiekien's, one of our colleagues here, who said this is a transnational offense. And it's a transnational offense for one simple reason, that if you say these three respondents and others who shall be defending in other courts are terrorists, everybody from Mossad, from KGB to China, they would be interested to know who are these people. So that the issue cannot be, is a serious issue. So that, Your Honor, when you say that people are engaging in terrorism, you must not take the judicial notice. That is an absolute serious issue. And the respondents are saying, we are here because we are victims of repression. We are here because the democratic freedoms, the fundamental freedoms that are expected in a constitutional democracy, in a functioning constitutional democracy, are being peeled off. There is a clawback on those freedoms that makes Kenya a constitutional democracy. And when we talk about this international issue, that this is not just a Kenyan thing, we speak with the knowledge that, for example, in the current issue of The Economist, which I believe some of us have had an opportunity to go through it, this is how much this has attracted everybody. Because when you say political protests are people who are terrorists, everybody gets concerned about that. And you've had in the current issues of The Economist, where the issue is being raised, that Kenya, which has been the only functioning democracy in East and Central Africa, something absolutely wrong is happening. And Your Honor, part of that thing that is very wrong that is happening is the reason why we are before this court. This freedom, the democratic backsliding that is taking place, must not be permitted. It must be nipped in the bud. How is it nipped in the bud? Your Honor, we had indicated also when we had a previous argument that we are also itching to go to the High Court if that be the case. But Your Honor, before we get there, the first port of call for purposes of protecting Kenyans must be this court. This court must reject the invitation to try and have a scenario whereby state repression is going to be processed against the citizens of Kenya. Your Honor, an application of this nature, point number 2, is an exception to the general rule that on the first day when accused persons appear in court, will appear in court, there should be some evidence against them given by the state. But, Your Honor, the issues here is that because in the particular case, you are having a situation whereby, contrary to the exception that there should be evidence, you are being requested, put these people in. Article 20 of the Constitution and 21 requires this court at the initial stage to ensure that there is protection of the fundamental rights. Your Honor, the third issue is on the fact that, or actually before I go to the third issue, I need to, at this stage, to emphasize this fact came out through yesterday's cross-examination. Your Honor, because the Kenyans in the past have suffered oppression, oppressive prosecution, there's an important thing that happened under the 2010 Constitution, which is that what happened under the 2010 Constitution is that your side, the adjudicator, our side, the lawyers, and the side of the prosecution was put in the hands of lawyers. This is not by accident. This was to ensure, Your Honor, that people in whom the liberty and rights of Kenyans will be placed are trained and cultured to respect freedom, the rule of law, and people and their basic rights. That is absolutely important. A long time ago, I believe Senior Kalonzo, Ireri, and Ondieki are aware of those days. Today we are having 3 lawyers representing the DPP. We used to have the police. We have the DPP Act. We have Article 157 of the Constitution. What is the purpose of that? To ensure that before the respondents or any other person loses their liberty, people trained and cultured as lawyers, people who know the law of evidence, have satisfied the court that we have looked at this matter, and in this matter, it is appropriate that liberty be lost for a while. Your Honor, what is it that we had yesterday during cross-examination? Your Honor, what we had yesterday during cross-examination, and we have it on oath by Desterio. Desterio told us, I prepared this application, CID headquarters. They walked across the room somewhere to Mazingira, as my learned colleague Andrew Muge got it from there, and came with the application to Kahawa. They got it signed. Your Honor, that is very, very serious, because as advocates, and I don't want to deal with it at the advocate's level, I want to deal with it at DPP's level. An advocate, you cannot sign documents prepared by lay people. Desterio is a layman. Desterio cannot prepare an application to take away anybody's right under Article 49. This application, he said it and I repeated it. And I said, oh, awesome, if that is what happened. He said, I did it, there was a typographical error. To say why he said 14 in the application and 30 in the affidavit. Your Honor, the Constitution was written to ensure that prosecution powers are not shared between the prosecutor, between the DPP, and the police. So we cannot have a scenario where you are having documents prepared at CID headquarters, signed by advocates working for the DPP, and say, take away the liberties of Kenyan citizens. Your Honor, Article 157(6) of the Constitution requires the DPP to be independent. That independence, given the Kenya's history, requires independence from two things: independence from the police and independence from the president. That is the history we come away from. So that, Your Honor, when you get into a situation where the DPP is prosecuting on the basis of affidavits and applications prepared by the police, it means that the protections given by the Constitution and Article 157 is being taken away. The duty of this court in those circumstances is not to countenance such a scenario. Because, Your Honor, we used to have the times when, for practical purposes, those powers of detention and prosecution and the police were conjoined in the offices of Bernard Chunga and Francis Sang. We cannot allow a situation where those 1980 days comes back after the 2010 Constitution, that there is a fusion, that the current DPP and Amin want to act together in this kind of manner in the name of fighting criminals. That is not permitted by the Constitution of Kenya. So what's our point? The applications before you is absolutely defective. It is not a DPP's application. The police have got no power under the Constitution, under Article 49, to take away the liberty of any Kenyan citizen. Your Honor, the fourth point is the law of evidence. I hope sometimes I don't see very well. In the case of Githunguri, the basic law of evidence is what? What you can see, what you can perceive, and what is commonsensical to everyone. Now, Your Honor, in the famous case of Githunguri, at a section, they highlighted an important section of the Law of Evidence Act, Cap 80, which is section 3.2 of the Evidence Act. It says as follows: a fact is proved when, after considering the matters before it, the court believes it to exist or considers its existence so probable that a prudent man ought, in the circumstances of the particular case, to act upon the supposition that it exists. Guided by the commentary in Sakal on the provision of section 3.2, as prudent men, which we believe justifiably ourselves to be, we hold that, where applicable, the matters mentioned in the applicant's affidavit, to which he deponed from personal knowledge, have been turned and established into facts. The degree of probability is so high that proceedings by the sound rule of common sense, we are justified in regarding them as certainty and to act accordingly. Applied to this case, what, Your Honor, this means is simple. Given the fact of all that we know about the events from June 25 to Sabasaba to today, the questions would be, in good conscience and based on section 2, can this court be satisfied that the police and DPP has brought terrorists before you against whom you should detain as required by them? Your Honor, when we talk about training and culture, it's because you are supposed to see what is the mischief. And in seeing this mischief, I am urging you that the law itself will not permit you to reject the evidence of our eyes, evidence of our ears, and the videos that we are seeing, and say, these are the people burning police stations and all this. We've seen people walking in the company of policemen in their way to dealing these things. Supermarkets have been destroyed when the police vehicles are just outside there. We cannot ignore these things. And because we are dealing with a political situation and say, whoever the police brings here, we are going to believe it. Your Honor, the reason why it must be lawyers adjudicating people's rights is that it is illegal for a lawyer to be an idiot or a lawyer to act as a person who does not understand reality. If a case comes before you based on alternative reality, on alternative facts, this court is prohibited by law and training that all of us have trained to reject such a charge and to allow any persons to lose their liberty on that basis. Your Honor, talking about that, there is also an important thing that you must understand. I believe you saw Mheshimiwa call me when we were dealing with preliminary issue. Your Honor, amongst those things that we have watched, and we shall be bringing to court if we get to that stage, would be this. A day before, he was arrested, 2 days before. There is somebody called Oscar Sudi who has been protected previously by the constitutions. He said, we are going to arrest you as a precursor to arresting other people. Mukunji the following day dared him. He's a brave Kenyan, and we hail him for that. That, come and arrest me if you can. Well, probably he thought Sudi is a small man. He was actually arrested the following day. And this is why he says that we must make it apparent that when he says that I am here pursuant to persecution, and they have dragged two other people whom I don't know, whom we have just had a chance meeting. One of them is a boda writer. You know, he says there is at least video evidence. The same video evidence that is showing us who is doing all these criminal activities, which he believes they have either been sponsored, aided, or abetted by the Kenyan state, as shown these young men with clubs and weapons that have been molesting other Kenyans. So that, Your Honor, those are the circumstances that we cannot close our eyes, and that our training does not permit us to close our eyes to, and we deal with them as they were. And why should we be very afraid of this? We should be very afraid of this, Your Honor, for one simple reason. That when we speak for the reasons when the trial a long time ago used to happen, and I'm happy I grew up in Nakuru and as a teenager, what would happen would be, you would have a situation whereby people like Karaoke Chotara, a lot of these young people may not know who was Karaoke Chotara, people like Wilson Leitich, they would mention this and this is an enemy of the state. These people would be arrested, taken to Nyayo House, tortured. Some of them would be jailed at night or early in the morning. Others would live there maimed, and others died. And this is the reason, Your Honor, when we say pre-trial detention, and I believe that is why all of us have been constraining to tell you, the reason why we are all here, it is because it starts here. If the Your Honor were to say it is okay, it will open the floodgates. But we are here to say this is not okay. It must start before the judicial officers where they want to start this thing. Your Honor, occasionally, I had to be sent ping by Ndegwa for me to come when we came for the first time to this court. I didn't even know where it was. Because all that we know is that this is a court where terrorists are taken. I've never acted up to today for a terrorist. So I've never come to Kahawa. So I got I got this information that this is where the court is. But there is something there that is important. That occasionally you would hear, when you are dealing with the cause of strikes, that at the CID headquarters Kikiumana, then you hear, huyu tutampeleka, this place is called? Kahawa. That is something we've had in the course of dealing with the criminal law. I didn't know why this was the case, but yesterday it started to make sense. Because Desterio testified that he can make documents at CID headquarters, get them signed in Kahawa, and people to be prosecuted in Kahawa. Your Honor, this is something the court may not probably know. But, Your Honor, if this appears to be what is happening, Your Honor, I urge for the dignity of this court and the judiciary, this must be brought to an end. If Kipe Mongai is not representing a terrorist, there is no reason why he should come to Kahawa until the day when a terrorist tells me to defend them. If these people are not terrorists, they go to Runyenjes and they go to other ordinary courts, not to be in such kind of cages that were designed for dangerous criminals. Your Honor, the final point that I wish to make is this, is that in the affidavit, Mr. Jagua will deal with the bulk of that affidavit, but the only point I wish to point out in this affidavit is this. In this affidavit, we asked, you was a difficult witness, you saw that, Your Honor, but we tried to get something out of him. You gave us an inventory. We saw an inventory. We asked, what are these dangerous things that these people are using to fight? We didn't see, and I've come that through my other lawyers who deals with these issues, and police reports ordinarily, we caught him with guns, bazookas, all these kind of things. It is the reason why people are called terrorists. We got them with hundreds of millions engaging in money laundering, which were not for any investment activity. We believe this is. Here, even the money is not there. Your Honor, we were told there is a notebook. There is people's diary. Ordinary things that all of us have if you go and search Tawakaza, the parking. You take those things, you say, because these men are in possession of these things and a mobile phone, these are terrorists. Your Honor, back in the dark days, there is a Methodist priest who was charged with sedition. I don't know whether Senior Carlos remembers his name. I'm forgetting his name. He was charged with the sedition based on the contents of his diary. We are seeing the reenactment of that. You are being told there is a notebook, there is a diary, personal not Father Kaisa, there was a Methodist priest. It was being done by the law firm of Kamaukuria and Keraito, specifically by Kathuriman Toinoti, my master, who is now judge of the Court of Appeal. And in this Methodist church case, the substance of that sedition charge was what he had written in his diary. What's the point I am making? Yesterday's, the affidavit before you and that inventory reminds us of the day when a Methodist priest had to be charged with sedition based on the contents of his diary and after going through harrowing torture at Nyayo House. Your Honor, the time to stop this is now. I beseech you to uphold the constitutions as your oath of office requires and in accordance with your training and culture as a lawyer. We are most obliged.
Deal with the issues of evidence.